council worked out the mitigating language, and it's acceptable for the defendant saying the state as printed.
That looks good.
All right. And council can take about a half hour plus each, or thereabouts. For
Judge, I don't think I mean, I didn't time it, but I don't feel like I'm super long. I'm not using PowerPoint.
So I don't have to operate the lights. With it.
No, thank you.
You might.
Yeah, okay. All right, let's bring the jury, please. Okay, our jury's back. Please be seated. All right, members of the jury, we're now going to have closing arguments for the penalty phase. As I've told you before, what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. Ms. Jensen.
Thank you, Your Honor. May it please the court. Defense. What punishment does Donald Hartung deserve based on the law and the evidence for the brutal, financially motivated, triple homicide that he planned and he committed? That is the question before you. The state is asking for death. The defense is asking for life. But it's not what the state wants, and it is not what the defense wants. It is what the law and justice ask for you to decide, the ladies and gentlemen of our jury. Some of you may think that life without parole is worse than the death penalty. But if life without parole was worse than the death penalty, the defense would not be asking for it. And it's not about what is worse if it were you. It's about what the appropriate punishment is for this man for what he did to his family. He took these three people and he turned them into those autopsy photos that you have in evidence. Ms. Wilson said in her opening statement yesterday that these murders are not justifiable, they are not excusable, and the state agrees. And you know what else they're not? They are not related to or a product of their brain doctor's diagnosis 4 years later. The state is not disagreeing that this defendant has some brain impairment. You heard from our own expert. He testified. This defendant has mild impairment. But what we are disagreeing with is the level of the severity that Dr. Colino wanted you to believe yesterday. And think about it. At the time of these murders in 2015, this defendant was working at the same job that he had had for 10 years, living by himself, taking care of himself, paying his bills, cooking on Tuesdays, driving, taking care of his dog. And you heard testimony from Dr. Turner that just August of last year, there was a video visitation. And there was a Catholic group that came to visit Mr. Hartung. And Mr. Hartung engaged in theoretical conversations about Catholicism, talked about complicated books that he was reading, talked about dates, times, details. Does he have mild brain impairments? Apparently. Is it mitigating evidence for you to consider? Sure. Anything is mitigating. But does it explain what happened on July 28th of 2015? That's what Dr. Colino said. He said, these things happened, and the defendant's FTD explains it. Dr. Colino, smart man, no question. He's a doctor. Never, not once, 0 times been hired by the state. 95% of his practice is testifying about mitigation for defendants. He was retained by the defense in this case 6 months ago, is getting paid more than $50,000 to give you his opinion that he admitted is based in part on speculation. He can't tell you definitively that Donald Hartung has FTD, frontotemporal dementia. He can't tell you that this defendant had it at the time of the murders. He can't tell you if he does have FTD, when it even began. Dr. Colino said he thinks it started when Mr. Hartung became a Wiccan. $50,000 and an expert, and that's his opinion. So with all those inconsistencies and uncertainties, that doctor wants you to believe that at the time of these horrific murders, he used the word horrific, that this defendant could not conform his conduct to the requirements of law, and that at the time of these murders, the defendant was suffering from neurodegenerative disease. But ladies and gentlemen, that is not the wording of the statute. Dr. Colino read you the statute correctly, and you're going to see it in your jury instructions. It reads, the capital felony, these murders, were committed while the defendant was under the influence of extreme mental or emotional disturbance. Dr. Colino put his own spin on the language and said, to translate it, that the defendant was suffering from this neurodegenerative disease. $50,000 does not change the language. The language is the language. The most profound and accurate statement that Dr. Colino said was when he looked at all of you. And he said, the jury knows more about this case than I do. You all sat through a week and a half of the evidence and the testimony and the witnesses and the facts. He didn't. Was it this speculative FTD that caused this defendant to murder his family? Or was it just good old-fashioned greed that you saw during part 1 of this trial? Dr. Colino has not treated patients since 2011. He couldn't even tell you the symptoms when asked by Mr. Myers of what he would expect to see. Mr. Myers said, well, what would you expect to see in someone with mild atrophy? Well, I don't know, it varies. Okay, well, what about with someone with moderate atrophy? Well, that varies too. He couldn't do it or he wouldn't do it because perhaps it didn't fit in with his diagnosis. Dr. Colino did not watch this defendant murder his family. What evidence, not speculation, what evidence do you have that this defendant was under the influence of extreme mental or emotional disturbance, or that his ability to conform his conduct to the requirements of law was substantially impaired? None. He cooked. He killed 2 people. He cleaned up. He killed again. And then he went home. There is no factual evidence that at the time of these murders, this defendant was under the influence of anything but greed. But there is evidence of calm, and cool reflection. And that is one of the three aggravators in this case. The cold, calculated, and premeditated aggravating factor offsets the mental mitigation that Dr. Colino testified to. Did this defendant's actions on July 28th of 2015 sound like someone that was impaired by a shrinking brain or FTD? Or did his actions sound and look like someone who was in control and on a mission? The cold and calculated premeditated aggravating factor exists beyond a reasonable doubt when the facts show a particularly lengthy, methodic, or involved series of atrocious events. And that describes these murders to a T. This defendant went over there earlier than usual. He left his dog at home. He took clothes to change into. He cooked first to keep things appearing normal. He fed his family their last meal. He brutally murdered John. He put something over his mother's head. He tortured her by cutting her pinky. He murdered his mother and then dragged her down the hall. He covered the bodies with mounds of stuff. He set the rugs on top of the bloody drag marks. He cleaned up. He waited for Richard to get home from work. And then Richard struggled for his life. This was a particularly lengthy, methodic, or involved series of atrocious events. And therefore, it was cold, it was calculated, and it was premeditated. And those facts go against the speculation of Dr. Colino. Now, the state would have no credibility if I suggested that there was not mitigation in this case, because there is. This defendant had a less than ideal childhood. Dr. Turner testified to that. The state elicited that testimony from our own expert because it exists. But ladies and gentlemen, put it in context. This defendant's traumatic childhood happened over 50 years ago. How many other people in this world have traumatic childhoods? Some probably worse than Mr. Hartung. But they don't all go out and murder their mom and their two half-brothers. Is this defendant's childhood sad and unfortunate? Sure. Is it mitigating against the death penalty? That is for you to decide. But does it outweigh what he did to his family? You heard that this defendant's mom was neglectful when he was young because she had to work. She had to leave him with other family members. His father abandoned him when he was a baby. And again, that is all sad and it is unfortunate. But it is not as sad and unfortunate as the murders of these three victims. You heard testimony about sexual abuse that this defendant suffered when he was a child. And it is despicable and it is disgusting, and no child should ever have to suffer those type of acts. But it does not outweigh the repeated hammer strikes to John and Bonnie's heads, or the slitting of all three of their throats. You have pictures and evidence of Mr. Hartung. You have his integrity award. You have his Indian membership. And if you pick those up while you deliberate, and you should, that's what they're presented to you for. But if you pick any of those up and they warm your hearts, pick up that hammer that you have in evidence, or pick up those autopsy photos. Which hold the most weight? I want to talk about Mr. Hartung's age. He was 58 years old at the time of these murders. He is 63 years old as he sits before you today. And that might be weighing on some of you, and rightly so. 63 years old. He had an MRI 2 months ago. His brain is shrinking, and he's got some mild impairments. But ladies and gentlemen, his punishment should fit his crimes, whether he was 48 or 58 or 88. He should not get a free pass from the death penalty because he's getting up there in age. What does he deserve as a sentence for what he did, regardless of how old he is? Does his age outweigh the murder of these 3 human beings? These are horrific murders with 3 aggravators that are sufficient to justify the death penalty, regardless of his age. And remember, this is not a numbers game. The state has presented and proven 3 aggravating factors beyond a reasonable doubt. The defense has presented many more mitigators in number. The state is limited by statute. The defense is not. But what weighs more? What weighs more to you? The quality, the power, and the strength of these 3 aggravators outweigh any and all mitigation presented to you. Because the enormity of these 3 murders simply cannot be outweighed by the mitigation that they have presented to you. The state submits to you that the one aggravating factor of murdering 3 people, not 1, not 2, but 3 people, in and of itself outweighs any of the mitigation that they presented. But you also have the financial gain, and you also have the cold, calculated, premeditated manner. And if you think about it, it's like weighing 3 boulders against numerous little pebbles. The boulders are the aggravators, and they are heavier than the pebbles. All of you agreed in jury selection that you could each personally and individually vote to sentence this defendant to death if it was appropriate based on the law and the evidence. You know what he did. You know why he did it, and you all know what the appropriate punishment is. He deserves the ultimate penalty for his ultimate crimes. And it will take the strength and the courage of all 12 of you to vote to impose that sentence. And please know that we all know that your vote is a heavy burden and a huge responsibility. But his death would not be on your hands. Justice would be. Because a murder is the taking of an innocent life without legal justification. The death penalty is a lawful and legal punishment in the great state of Florida. Please indulge me for one final thought. You have heard hours and hours of testimony about Donald Hartung during this portion of the trial. And you should. You should have anything and everything that helps you decide what the appropriate sentence should be. But when you go back to deliberate what the appropriate sentence is for this defendant, and you think about his life and his character and his background, the state asks that you take 5 minutes, 3 minutes, 2 minutes of silence to think about the 3 lives that were taken and the manner in which they were taken.
Approach.
As I was saying, the state asks that you take 5 minutes, 3 minutes, or even 2 minutes to think about the 3 lives that were taken in this case and the manner in which they were taken. 78-year-old Bonnie Smith, 49-year-old Richard Thomas Smith, and 47-year-old John William Smith. Thank you all so much for your time and your attention during the course of this entire process.